I'm going to talk about legal stuff that's a little bit boring, but I'm going to try to make it interesting for you. And no matter what your level of experience is, you can follow this. And then on the table, there is, in the middle, one of these slideshows. If you can't read the small print, don't worry, I'm going to explain it to you. Okay, so let me start. The basic documents you need are a will, a durable power of attorney for finances and health care. Optional documents you need are a directive, a living will, a declaration of guardian. There's not going to be a test, I'm just going to tell you. And a helpful gifts letter on personal items, transfer and death deeds, passcodes for your electronic documents, a financial journal of your assets and insurance, and there are tax planning and privacy issues. You may want to use trust where appropriate for privacy or flexibility, and you can always amend your documents. So if you and your wife don't agree on things, keep in mind she has a will, you have a will, and if she wants to give to her favorite charity, the Girl Scouts, and you want to give to Hope Church, that's fine. You don't have to have identical wills, okay? And if you're thinking about a guardian for your children and that's keeping you from making a will because she wants her family, you want your family, don't stop that from you making a will. You can have a list of people for executors and for guardians, but it helps your family so much avoid disputes, and it's really a gift. Your last will is your letter of testimony. It's a last will and testament. What's important to you in life? Why are you here? Why did God create you? Is it important for you to provide for your spouse? I hope so, Neil. And also, is it important for you to provide for children or grandchildren? Or if you don't have any children, for other families. And we always think about providing for children or grandchildren. But I also tell people or ask them, are you supporting anybody else in your family? Are you giving gifts to nephews? Are you helping your parents with their bills? Are you helping your aunt? Younger people can also give to older people. And everybody probably has some nonprofit or charity that gives their heart joy to help in one way. Okay, so the documents everyone needs. I just stated the last will and testament. In Texas, you have to have the right jurat at the back of your will. That's called a self-proving affidavit. It has to be witnessed by two people and a notary. If you don't have that, before you get your formal will, take the time to do a handwritten will. I have probated about 5 handwritten wills in my career. They're harder to probate. You have to bring in handwriting people and validate the terms that you would have in a self-approved will, but at least do a handwritten will. A handwritten will, my name is Patti Kelly. I'm married to Neil Kelly. I have these 5 children. So the gift in your will identifies your children, the objects of your affection, appoints who you wish to be in charge, so the court's not in charge, gives gifts, then you sign and date it. So don't delay. If you don't have anything, don't be embarrassed. But get a formal will to make it easy for your family. You also must have in Texas, the attorneys are not just telling you this to make money. You must have in Texas a financial power of attorney saying who you trust if you become disabled to manage your finances. And you must have a health care power of attorney saying if I'm disabled, this person I trust to make health care decisions for me. And then you need to keep your own originals. In my opinion, a lot of attorneys like to keep their originals, but then they have trouble finding them too. It's up to you to keep up with your original. I always keep copies. Most attorneys do. A notary can verify this is a true copy if you lost it. Okay, the POA for finances. I have these forms in some of the packets, and if you need one, I can give you a copy if it's not on your table, so don't look for it right now. But the financial power of attorney allows you to give limited or full powers, and it allows you to decide if you want it effective now. Like if you're in the military and you go overseas, you may need your spouse to handle affairs, or if you want your kids to manage things now or a son, you can have it effective now or in the event of disability. Doctors determine you're disabled, not your family. And then you can sign it before a notary, and people always ask, can I revoke these documents? You can always amend your will.
If something terrible happens that you happen to get divorced, the will gift to your ex-spouse is not valid. If you had an ex-spouse on a payable on death account, that's still valid. So when you're doing these documents, you need to make sure they're up to date. And never, ever put a minor on a payable on death thing like a bank account. And when we talk about wills in a minute, I'll explain how you give gifts to minors. Okay, so people say, well, I just assume my wife gets everything. I'm not worried about that. Or my children, they know who they are. They'll just go prove who they are. So I'm going to talk to you about what happens when you don't have a will. Also, if you had an emergency, you're found on the highway and they don't know who you are, you will be treated in the event of an emergency. But say you need a surgery, the doctors look for who's in charge. And they will ask you when you check in for a surgery, do you have a health care power? Do you have a directive? And so I'm going to explain what those are. These are extra health care documents. The directive is your choice on end-of-life care, and everybody needs these. Even, my children, when they started having children, were asking me to babysit. And I have one daughter married to an attorney. And I said, sure, I'll babysit. Where are you going? Snow skiing. And we're flying. We're gone a week, and they had, minor child. I said, well, do you have a will? And her husband's an attorney. No, we don't have time for that. We just have time for snow skiing. And so I was like, no, you have time. He can draft one. Well, he was too busy. He didn't do it. And I kept, bugging her. And I said, I'll watch your child, but at least do a handwritten will. I'm not asking you to give me your children or your money. Just please make some directions. And so, I had to help her because he was too busy. And then the night before they were leaving, they hadn't signed it. The point is, if you have drafted a will on your computer, if you have made several drafts or signed different versions, you need to have a final, effective, valid will under the current laws. And so at the end, the night before she's leaving, we're rounding up witnesses, getting it notarized. She did it. But basically, anybody over 18 needs it. And so this is not just for you guys that might already have thought about this. This is for everybody. And my kids have had friends who tragically got hit by a car, died, jumped off a cliff, died. And I've helped their parents in tragic situations, and they realize, no one thinks doesn't know when they're going to die. And so you have to go through court and get a determination of heirship, get an attorney ad litem appointed to verify the heirs. There's a long delay. There's a lot of expense, and it ends up making people frustrated with the system. So even college students, people over 18, even if they don't have children, they need those documents in place. And then people ask me about a do not resuscitate. I don't issue those forms. A do not resuscitate is different than a directive. A directive talks about what your wishes are if you had a terminal condition expected to die within 6 months. Do you want just pain medicine and hospice care, or do you want to be kept artificially alive as long as possible? And so you choose that, and it's a directive to your family and your physician on your wishes. And that goes hand in hand with your health care power. A do not resuscitate has to be talked about with a doctor, and that's like, do not resuscitate me with CPR. And there's a new form in Texas, and you may be asked to sign it more than once. It's kind of odd, but they want to make sure you haven't changed your mind at any step in the process. And those documents, the health care, the directive, they can all be revoked, even the do not resuscitate, okay? So if you're thinking, I want this, but you change your mind later, you can do that. So don't let that make you hesitate about getting things in order. Okay, I'm going to talk a little bit about, if you have a will, what to do and what not to do. Do not write on your formal will. I have a lot of people that had another attorney draft a will, and they're just going to write on it and scribble out names, or they're going to put an addendum that's not correct. So if you try to change your will by handwriting things on it, you may end up revoking your will. So be careful about that. If you want to go to a new attorney and update it, or you want to try to update it yourself with some of the online packages, make notes on the side. Do not write on the original will, okay? And then get it done properly. Sometimes you may just need a codicil. An example is you have an executor who passed away and you didn't have an alternate. You may just want a codicil to update that person. Or let's say you want to give a gift to Hope Presbyterian Church or to Rotary or the Boy Scouts. You can do that through a codicil. A codicil is an addition to a will, but it has to be executed the same way as a will. And then basically, in Texas, you want your executor usually to be a family member or friend you trust, to be independent, to serve without bond, to be free of court control, so they have all powers that you would have, and the court doesn't control what they do. It saves time and money and energy. And basically, if you're an executor, it's not super expensive to file your will. What you do is you have a duty. If you know you're an executor and your brother dies, you have to notify the court that that person has passed, file the original will in probate court, and present yourself, take an oath to follow the will, and get letters of administration. And then after that, there's only one report you have to file with the court. You do have to place notices in the paper to creditors, and it streamlines things. It's very easy if you have a will. It's a perfect gift for your family. Now, if you don't, we'll talk about determination and heirship in a minute. But you can also plan so that your assets pass separate than the probate court, like payable on death, like with an IRA, as you all know, or a bank account. But you need to check those designations, because now a lot of the banks have closed and they just want you to do things online. And I've had some problems with some clients who remembered or thought they signed something at Bank of America, payable on death, to this person. And when they switch over their computers or they close their branch, the documents are not there. So if you go to the bank and you sign a signature card or payable on death designation, require the bank to give you a copy of that, okay? And then check with your bank, online or in person, what do my accounts say, okay? And then with the financial power of attorney, I want to talk about that just really briefly. A lot of people think, well, I'm not going to do the financial power of attorney. I'm just going to put my child on my bank account as a joint owner. It's really not a good idea to do that unless it's a small amount of money. For example, let's say you have a son who's brilliant and he's a doctor. I have one. Okay. And he's got a great reputation. Well, when you put his name on that account, he becomes a joint owner of that account, okay? And so let's say something happens and he is sued for malpractice, okay? That is his account, not just yours. So you have made him a joint owner of that account. So as much as you might trust a child, think about that. If you want to have some money set aside for funeral expenses or for expenses of administration to get the process started or to have a nice service, you could put an account together for that. You don't have to go buy a funeral plan. And that person, like when I was handling stuff for my mother, can take in a financial POA and be added as Joyce Evans was her name. And underneath I was Patricia Kelly, POA for Joyce Evans, okay? Now it might be you only have one child and no spouse and you want that child to receive everything and you don't want to have a will and you just want to do the POD account. That's okay, and you don't think there's any liability risk, but always have a will, because what if somebody kills you, a drunk driver kills you in a car wreck? You need somebody to collect what's due to your estate. You need an executor. And so I'm going to talk about trusts in a minute, but also this reminds you, never put a child on an account, because the court takes it over if there's a child on an account. Okay, I'm going to speed through some of this. I'm going to tell you about other good estate planning tools. Some of this is in your packet, and you're going to get more information from the Texas Presbyterian lady who's going to talk next week. But a new thing since 2015 is in Texas, you can now put on your deed to your house or any real estate a transfer on death deed designation. And what you do is you have to do it and record it in the deed record. So again, you need an attorney and a notary and file that. Like, when I die, I want the house to go to my spouse. and then it lets you do alternate. If we're both deceased, our house goes to our 2 children. You know, Daniel Kelly, Allie Kelly. We actually have 5, but this is an example, okay? And that works to immediately transfer the title on real estate. And so that's a tool that more people are using in Texas that a lot of people like. Okay, I'm going to tell you about charitable bequests briefly, but Josh and the Presbyterian lady will talk more about this. You need to be specific. You can't just say, I want my estate to go to charity. That's too broad, you know. There was actually a legal case when you go to these seminars that you can't believe how people draft their own wills, but, you know, they're creative. There was a lady in New York who didn't have any family, and she just said she wanted all that she had was from God, and she wanted it to go back to God. Literally, she had a will like that. And she didn't go to an attorney, but she did it herself. Well, when you have a kind of vague, you know, bequest like that, what the court has to do is advertise in the paper. We can't find this heir. There was an ad in the New York paper. God, there's a bequest for you in the probate court, you know, in this county. And then you have to wait like 30 days to see if anybody comes forward or not to claim it. Well, you know, some churches did, but it wasn't specific enough. And so what happened was the state of New York got her whole estate. So you have to be specific, not just, and then with Hope, you can give to the Hope Generation to Generation Committee, or you can give a specific bequest if you wanted to, the general fund or whatever. You can give terms. Now, the G to G can talk to you about what they prefer, and then Josh will be talking about that more too. But in any event, please think about that when you're drafting your will. Or if you're doing something like to your college, that's fine too, but help your executor by telling which college, not just like any college, which college and which fund or which endowment at your college. Okay, here's some charitable giving samples. One, you can just say, I give $10,000 to X, a person, give the whole name. I have a will right now where a woman did a handwritten will and she named her children but not their last names, and now we have to prove those children are the children. Put the whole names of any entity or children. Okay, it may help you to also, when you're giving charitable bequests, to think about what you own. So there's a tax planning guide in here from the Presbyterian Church to first sit down and say, okay, I have these assets, I have these debts. And nowadays, put your passcodes in there for your executor. It does not go in your will. I give a planning packet to my clients, and then when the executor gets in charge, they know, oh, go to Bank of America, then go to Fidelity, and then I have a funeral plan here, and it just makes that executor's job so much easier. So it's a gift to your children or your family to know that. You may want to consider giving your required minimum distributions to a charity to avoid the taxes on those. A lot of people consider that. And then also, this is a great new thing under the law, and the lady from Texas Presbyterian I saw on her syllabus is going to talk about it, but I want to talk about it because I think it's very cool. Now you can also, because the standard deduction got raised to $25,000 like for a married couple, you can now yourself set up a donor-assisted fund. It's called a DAF, D-A-F. And so what you do with a DAF, we'll talk about in a minute. But if you have a lot of creative ideas, some people do, you may want a charitable lead trust, or you may want a charitable remainder trust. The idea between those two are give to family first, then the remainder, if the family doesn't need it all, or you want to set aside some, then to a charity. Or a lead trust gives to the charity first, and then kids or family or friends later. Okay, the donor advised fund is very cool. It's a new thing, and I did see in your packet, Presbyterian Foundation put together a handout on it too. This is the fastest growing charitable method in the United States. Once you decide, let's say I have a client, for example, that sold a business, and they came into unexpected millions of dollars, okay? So they are giving to their kids, of course, but they have so much they need some tax advantages because they don't want to just give that money that they just now earned in this year to the government, which makes sense to me. And so they have set up a donor-assisted fund. They put aside money above the $25,000, and whatever you put in it, that is an irrevocable gift. So say they decide to put $1 million or whatever, I'm not going to tell you what they decided, into a donor-assisted fund. They get the tax deduction for that donation, okay? And they can take it off on their taxes, and then they get to direct who gets those funds. Every year, they get to direct, I want this much to my church, I want this much to this scholarship fund. The next year, they can direct more. So they control it like their own foundation. You've heard of the Gates Foundation, the Clinton Foundation, all these cool people that have made a lot of money in life. Well, you can do that yourself now. So it's a really cool planning tool. And I'm going to give you an example of it. Here's an example. Okay, let's say you could be talking about a little bit amount of money, and this is another thing, and I'm not trying to be a CPA here. My husband's a CPA, I'm not. But these are simple principles you can understand. Let's say you bought stock a long time ago because you were super smart, and you got Apple stock or some kind of stock, IBM or something, Dell, and you purchased it for $5,000. But now it's worth $50,000. Good for you, okay? But if you sell that stock, you have to pay capital gains of 15%. So in my little example, if you wanted to donate that stock to charity and you sell it first, you have to pay $6,750 to the U.S. Federal Treasury, IRS. Then the only amount you have left to give to the charity is $42,250, and so you have saved taxes on that donation of $3,630, okay? Now, what if you thought about it before you just sold that stock and gave it to charity? If you did like a donor-advised fund, then you can not have any long-term tax. You can put the stock in that donor-advised fund. And then the charitable contribution is a whole $50,000. And so the charity gets $6,750 more. And you get a tax savings of $12,000. So it's not rocket science, but it's very important to understand what you own and how much you may not know the exact basis, but your financial planner, or you may have it in your record somewhere, IRS will look it up and tax you on the capital gains if you can't remember. So be careful of that. And then here's what I was saying about find your quiet place, make a list of your assets. And I recommend husbands and wives do this together, because sometimes there's one person who's more the bill payer and the money manager, and then the other person is going out there making the money, or both of them are making money and they don't know where all the accounts are, okay? List where your accounts are, list where your bills are, because your executor also has to pay your bills before they distribute the assets to the heirs. And so, going back a little bit, I think I skipped some. The donor-advised funds are 100% tax deductible, and right now the annual gift tax exclusion, like if you're giving to children or anybody in your family, is $17,000 per year, that you can just write a check if you want to, and it comes out of your money, but the person you give to does not pay taxes on that. That's a gift. So if you need to reduce what you have under your name right now, or you want to, you can give to individuals in your family or anybody. And right now the state tax exemption is $12.92 million, and I'm going to guess most of us aren't above that right now, so you might not think you need to worry about that. But I just looked it up because I've been an attorney a long time. I graduated and got my law degree in '85 from UT. And I just looked it up because I remember it was really low. It was $400,000 was the only amount you could pass to your family without paying estate taxes, which are about 35 to 40%. And then for about 12 years, from '85 to '96, well, that's 11, it was $600,000. So if you did a will back in the day when the state exemption was low like that, you likely have a trust, a bypass trust in your will. That's okay, but you may want to look at that because you may not need it. But I really, really do like trust, and I'll tell you why in a minute before we go too much further. So I'm going to also open it up for questions at the end, so don't worry if I don't cover something you want. I wanted to mention again what happens if you don't have a will. If you don't have a will or a family member dies without a will, somebody has to apply to the court to manage things. You can't just take over assets or demand the bank give them to you. Either a family member or a creditor can apply to the court to manage an estate. There's problems, there's delays, there's extra costs. The court appoints an attorney ad litem to verify the heirs and research heirship and write a report. And the court often supervises things unless all the heirs agree that we want this person to be in charge of the estate. And we agree this person can be independent and not bonded. So I'm on a rotating list of attorneys that get appointed for attorney ad litem, and so I have to research ancestors. Even if you come to me and you say, I only have 2 children, and I know he only had 2 children and he never had a wife and he never had any children, or whatever. There's still research out there in case there's some unknown heir, an illegitimate child, a prior wife, an adoption, things like that. I was in court the other day, and somebody who'd been placed for adoption, the adoption usually doesn't terminate rights to inheritance. So, a young child who'd been adopted out of state was an heir to this estate, and it was a surprise to the family. So you want a will. You don't have to give to children. You can give it all to your favorite charity, or even if you don't have assets, you need somebody in charge to manage your bills and manage your funeral arrangements and manage any claims that are against you. There's a chart on each table. I'm just going to point it out, but I'm not going to make you read it or memorize it. A lot of people nowadays maybe have had a death in a second marriage or a divorce in another marriage, and so they just assume it happens all the time. I have a sister in that situation, and I've been trying to get her to finish her estate plan, because if you have children, if you have a second marriage and you have children from a different marriage, or your husband does, and you don't have a will, people are often angry and surprised, because in Texas, if you have children from another marriage, or your spouse does not get your share of the community property. The children get the share of the community property. So you could have a situation where even minor children are receiving an estate that parents had no idea that was going to happen, okay? And the courts don't fix that to say, oh, we had a good marriage, and give it all to the second wife. It is a statute in Texas and most states that say how the property flows. And this is from the Travis County Court, but it has pie charts too of what happens if you die, if you don't have children and you don't have a spouse, then parents and then also siblings inherit. And then if you run out, they have to go search for heirs, okay? So it can be very complicated with no will. Okay, I missed a couple, so I'm gonna go back real quick. So also, I didn't mention this, but you probably heard of the Unclaimed Property Fund in Texas. Everybody in Texas, in every state, has these. Like I said, New York got the Ladies' Gift to God. If you don't know where the assets are and you're the executor and you don't claim the life insurance, or you do not claim a bank account somewhere, what happens is eventually that property goes to the state where the property is managed, and you have to make a claim to get it. To get the property, if you ever see your name or your deceased family member on that list, you have to prove that you are the executor to claim that property for the deceased person, or you have to open an heirship or do an affidavit of heirship. So it's better to have your assets organized so your family can claim those and take care of things. And then when you do your will, put together like something like this that's in this packet, the list of assets, and update it. Put your passcodes in there so people can find your records, because now they don't want to send paper records. They want it all online, and then you might miss an account. If you had a funeral plan that was prepaid, put that in there, because often that is overlooked, and that can be a big, big help for your family. And I did have a little game, so we're going to play like a 3-minute game if you have a pen on the table, okay? I'm going to ask you a couple of questions, okay? This is the Jeopardy game. By the way, Neil's brother won Jeopardy 5 times. So we're super famous. Okay, here is question 1. There's going to be 3. Don't shout out the answer, just write down your number. And if you want to put it in your head and grade yourself in your head, that's fine. Who needs a will? Answer: 1, everyone over 18. Only the rich, 2. Or 3, only if you have assets. So make your guess. The first step in estate planning is 1, list your insurance, 2, draft a will, or 3, prepare a list of your assets and bills. The first step in an estate plan: list your insurance, draft a will, or prepare your assets and bills list. 3, estate planning experts are 1, IRS agents, 2, actuaries, or 3, estate planning attorneys. Okay, I'm biased. 4, one critical tool of estate planning is 1, durable power of attorneys, 2, computers, 3, mutual funds. Okay, we've got 3 more questions. Here's another question, number 5. Trusts are useful for 1, to replace a will, 2, to ensure nothing is overlooked, or 3, to manage assets. Now, I'm going to let you answer this, but I'm going to end with a little discussion of trusts. 6, estate planning involves 1, owning sufficient assets, 2, completion of an estate tax return, or 3, financial management during and after your life. 7, experts say 6, estate planning involves 1, owning sufficient assets, 2, completion of an estate tax return, or 3, financial management during your life and after your death, during your lifetime and after. 7, experts say the more modest your estate is, 1, the greater the expenses will be for estate planning, 2, the shorter your will be, 3, the greater the need is for careful planning. Okay, and here's a bonus question, extra credit. What is the current federal annual gift limit where you don't have to report the gift to a person to IRS? Okay, I'm going to read the answers real quick. You can just grade yourself. Number 1, everyone over 18 needs a will. 2, the first step in estate planning is make a list of your assets and your bills. Oh, number 2. Okay. Number 3, estate. Oh. Oh, I'm sorry. Number 1 on question 1. On question 2, number 3, estate planning experts are number 3, estate planning attorneys. 4, one critical tool of estate planning is number 1, durable power of attorneys. Trusts are number 5. Trusts are useful to number 3, manage assets. I'm going to end talking about trusts. 6, estate planning involves number 3, financial planning during your lifetime and for after your lifetime. Number 7, answer is 3. The greater, experts say the more modest your estate, the greater the need for careful planning is. And I want to say something about that. If you have somebody that dies and they have more debts than assets, and you're the executor, don't panic. You don't have to pay the debts. You're not liable as executor. And if you're managing somebody's care, always sign as their health care power of attorney a contract for health care, for home health aid. Don't put your own name. I would put Patricia Kelly, Healthcare Power for my mom, Joyce Evans. You don't want to be liable for somebody's debts, and you're not liable by being the executor. And then here, the bonus question. The annual gift exclusion amount right now is $17,000 per person. Okay, so raise your hand if you're 100. Yay, you're smart. Okay, now I'm going to talk really briefly about trust, and it's in the slide too, but I kind of went too fast. People are sold trust a lot here by financial planners rather than attorneys in Texas. But what I would say is I love trust, and I do trust too. They do cost more than a will, but a trust can be generational. It can be for your spouse, for your children, for your grandchildren. One good thing about a trust, if you've been married a long time to a spouse, is when you give your gift through trust to your spouse, you can provide that if everything is not used by that spouse, or you can even divide it, 50% for the spouse, 50% for children. It's a contract with your spouse on long-term management of your estate. So long-term married people really like that for one reason. It's also private. So if you happen to manage everything and have a transfer on death deed, have your IRAs payable on death, and have your funeral prepaid, and everything goes smoothly, you may not have to file your will in the public courts, and you may not have to do an inventory, okay? That's a list of assets. So it's private. It transfers assets to whom you want, and it also makes an agreement, in some cases, a marital agreement, because each spouse gets their own will. And if Neil leaves everything to me, and I'm rich, I'm really just rich with children, then I can get married again and give everything to a second spouse. I wouldn't do that. I don't think I would, but but you know, we need a trust, okay? So basically, it's an agreement of whatever you give, y'all are owning together, sort of like it continues from generation to generation. You can amend and do a living trust and change it as you have more kids or grandkids, and then you can put charitable bequests in there too. So I really, really do like trusts if you'll take the time to consider those. Sometimes you must have a trust. If you have anybody under 18, you cannot give them money for college at 14, okay? You have to have a trust in your will called a testamentary trust, somebody in charge of that, or you can form a college trust. You can do some of those accounts for college, but also if you have a parent who's disabled or somebody who needs to be on Medicaid, or you have a Down syndrome person in your family or somebody that can't manage money past 18, you must have a trust. And you also may need a guardian for that disabled person. So I usually recommend when you do your will, have a contingent trust for any minors, have a contingent trust inside your will if anybody's disabled. But if you give money to somebody who's on Social Security disability or a Down syndrome child wanting to help them, and you give it directly to them, it can knock them off of government benefits, okay? So trust can be really a lifesaver and can help you with your unique plan. So I also do recommend you sit down with somebody and not just guess on what would be best for your family. Okay, I'm going to open it up for questions now. Okay? Sure. Okay, that's a great question. I actually looked it up last night because if you go to some of the bigger law firms, I'm going to tell you, you're going to find it's a flat rate usually, and they'll charge you, and I'm not criticizing these firms, I just know them, okay? And they have a packet, and it looks pretty, and it can be big, and it's usually some of this paperwork that's pretty standard, plus your will, plus your trust. Always have a will with a trust that takes care of anything that you didn't get into the trust, because you might die in a car wreck and have to collect that claim or get a tax refund. And everything, it's really hard to get everything in the trust because you keep inheriting property perhaps, and then separate and community property you need to talk to an attorney about too, because you get to control who gets your separate property that you inherit or you brought into marriage, and your spouse does too. So husbands and wives don't need identical wills. They need to disclose what they own and figure out how to manage that correctly. But in Texas, usually the minimum amount for a trust is going to be around $18,000 to $2,000 up to $5,000. I know that's a lot, but in my practice, I usually don't charge more than $2,500, depending on how complex the trust is. It's like $1,800 to $2,500. Now, I looked up in Texas for the cost for a will, and it said, this is just a Google search I looked at last night because I thought that question might come up. It said, usually in Texas, the price for a will is $200 to $300, up to $1,500. And I donate wills to silent auctions, like for charities. That's one way I can give back. And I usually value a will package for a married couple at $500, like a husband, wife, and POAs without a trust. But honestly, when I started my own practice, I do the work myself. I don't have a staff. You know, I office with other professionals, and I used to office with 2 attorneys that retired. So I don't have to handle a big overhead. So I actually currently have been doing wills for $150 to $200 a person, and give a discount if there's 2, you know, husband and wife, because I want everybody to have a will. And if you look online, when the question was, is a computer important? Don't just type out a will and then think it's good or get on LegalZoom and not execute it correctly. A handwritten will means all in your handwriting, okay, if you're going to do the will yourself. Or if you print out a will online with a packet like that, make sure you finish it and you get it executed properly. LegalZoom, I think the wills there are $150 to $300, similar to what I quoted, and I think the trusts on LegalZoom are around $15,000 to $2,000 too, if you want to go that way. Somebody else had a question. Yes? Okay, well, that's a good question. You know, remember when I pointed out that right now the estate tax exemption is $12 million, but when I first became an attorney, it was $400,000, and then for about 11 years, it was $600,000. Now that we live in Austin, or most of us, our houses are worth probably, most of us, over $400,000 or $600,000, and it's kind of shocking how much assets have appreciated. But in the CLE, the continuing legal education classes, I have to attend. I just finished some for October, 22 hours. Basically, trusts are becoming more favored again because they have not changed the estate tax exemption. It's going to phase down to, I think, $7 million in 2025, but the government can vote, and they have committees now, and I'm not trying to be political, but Bernie Sanders is on the estate tax committee. He's one of the chairmen of it, that they want to get rid of capital gains. You know, they want the step up in basis that you get, and they want to start taxing more on capital gains. And there's a movement to lower the estate tax exemption back to some of the rates that were much lower before. So a lot of people are putting assets in trust because of the privacy issue, not to get away from the government, but to have some planning mechanisms rather than have everything in your name. And then one more thing I want to say about Texas. We all have insurance. We have to for our cars and houses, hopefully. But if you get sued, let's say you're a doctor and you get sued for whatever, or you're a builder and something happens, a fire, somebody falls off the roof of a building you're constructing. Okay, you can get sued. In Texas, what's protected, if you were sued and there's $1 million judgment you never expected to be against you because you accidentally got in a car wreck or somebody died in your business, you can keep your house. A creditor can never take that. You can keep anything that's in an IRA or a retirement plan under your name. And then if you're married, you can keep $60,000 of personal cash or securities or, liquid assets that a creditor cannot get. But if you have more than that in your name, you just have a savings account and it's got $300,000 or something, then a creditor can claim your assets if you happen to come into a situation where you owe someone. So another reason for a trust or a family partnership or a family LLC or setting up something that involves other people is the courts are a lot less likely to attack jointly owned assets like that or trusts that provide for children and grandchildren. They can try to, but once it's not in your name, it's not solely your property anymore. So that's another reason some people are enjoying use of trusts. But you don't have to use a trust. That's a personal preference. It gets you. I have some articles on it if you want to give me your email and you can read up on it. But basically, trust can do things as far as help manage property. You don't have to pay a lot to go to probate court, but there's no reporting, there's no registration of the trust, there's no accounting in court of what is in the trust. So those are definitely benefits. Yes. Yes, I like the PODs, but you have to check and make sure you've done them correctly. And then also, usually an IRA, it's good to keep a person's name as a beneficiary instead of a trust. Go. Okay, there's kind of a difference of opinion with some attorneys. Some attorneys like you to have a life insurance trust. If it's a big insurance policy, a trust is a good option because the other thing I didn't mention, like, for example, we have 5 children. When they were younger, we had a trust. You can make your trust go past 18, like through the college years. You can put special provisions. We'd pay for private school. We pay for this. You can say special wishes in a trust that help the trustee manage that money over time rather than somebody just giving a huge lump sum to someone who's 21. So trusts have the management part of it that you can put your own footprints, as we would say, of how you would want this money to be prudently managed. And some, like, I've had some doctors I've helped, and they had big estates. They would have their trust go for generation to generation and annual distributions to stretch out the money so that one person doesn't receive a lump sum and just spend it all, okay? So you can put your special wishes in there of what the trust funds would go for. The other thing that some people have is you may have somebody in your family who either isn't very good with finances or may have some, like I said, disabilities or unable to manage money. So trusts can help you. You don't have to have a bank be the trustee. You can have somebody that you would trust. And another thing is, if you have an old will, the tendency in the past was lawyers used to put themselves as executors or trustees. And there was a big lawsuit in San Antonio where a big law firm got sued for doing that because a woman with a large estate had to always ask permission from the attorneys to do everything or to get money out of her trust, and she was confused why that was. And she was told, well, your husband wanted a trust so you wouldn't waste money, and they put us in charge. But really, they were really making a lot of money. And so it went like to the Supreme Court of Texas, and they said, no, attorneys do not need to be trustees or executors unless that person has no family or friends that they would trust, and they have specifically asked that law firm to serve as the executor and trustee. So look at your old wills too and see if the people you appointed are still here, or they're still your choice. And you can update. That might be a codicil just change. Two weapons? Okay, I'm not familiar with the gun laws. Actually, there are people who have called me and they want to set up a trust to own their guns. That's a Texas gun trust, and I don't do those, So there are some attorneys that help you with that. And then this is one funny Texas thing. Okay, so, you can put specific bequests in your will, and usually women are more sentimental, and I'll get some long list of their bequests to people. And like my grandmother had dolls, and then my sister who passed, she had toys. Who's going to get the toys? Okay, or books. But anyway, and then when I ask a man sometimes, do you have any special items of sentimental value that came from your family that you want to pass down? It's really true. Men usually have, at least in my experience practicing in Texas, there's a lot of trucks that are important that get listed, or vehicles that go down to certain people. And then, I have had several people that like to pass down family heirlooms. And when we talk about heirlooms, I've gotten lists of rifles, which rifle goes to which person. So you can do that. Your will is your will. Any other? Okay. Okay, that's a great question. So there's this rule of perpetuities that most attorneys don't even understand. It'll be a clause in your trust, and that will say the trust can't continue more than this many generations plus 35 years. But it works out that it can be for this generation, your children, your grandchildren, your great-grandchildren. So the trust ends when it runs out of money, or you can put clauses in there, like if you have adult children, to allow them to choose based on what the laws are at the time to distribute and close the trusts, or you can allow them to, if it gets to be what we usually term, like the funds are low enough that they want to distribute, and you can put, like, when it gets to be 50,000, just distribute, whatever. You can put a number in there, or years. Yes? Okay. Okay, that is a really good question, because that comes up often. Do your will now, while you're all here and able, and update what you have, and encourage your children too. Because in the legal journals, like, somebody can make a will or sign these power of attorneys if they have a lucid moment, meaning they could already have Alzheimer's, but know who their family is and know what they own. They have to be, usually, at least what I do, is interview the person, not the family, saying, Mom told me she wants me to have everything. The client is the person I'm drafting the document for. So if you know the objects of your affection, who are you, who is your family, who do you trust to be in charge of you, and what do you own? They need to have a general overview. They don't have to know the exact number in their bank account, but they have to understand and have mental competency to do that. If there's a question to avoid a family dispute, I have had family disputes where, Mom had a stroke, she can't sign anything, but then you have improvement and you can talk, and even if you can't sign, if you can indicate, I had a blind woman and I read her will to her. We had witnesses watching her say, yes, that's what I want. If you can make your mark, and it is you, and the notary can ID that person, you can make a will. We used to have oral wills in Texas, but we do not allow that anymore. That's too much confusion. So people can improve after they've had a medical setback and make a will if they haven't had one, or power of attorneys. And there's a State Bar article talking about trying to avoid guardianship, that if you don't have those documents, you have to apply to court to become somebody's guardian. And I didn't go into that a lot, but that's expensive. It requires a person to get an ad litem to advocate for them not to have guardianship. Then every year you have to renew it with the court, and the court monitors every expense for that person. So you want the health care power and the financial power, so you don't need that. And when there's a question, another thing that can happen is you can ask the doctor, do you believe this person has the ability to sign legal documents? And they know about health care forms, and they know about power of attorney forms. And so there was one elderly man, and there was a dispute in the family whether or not he could or could not understand things. And so I said, well, take these questions to his doctor and ask the doctor if they will evaluate him and say yes or no. And if the answer is no, you're probably going to have to rely on your backup plan going for guardianship. You could also have a case where dementia, somebody who likes their family when they're sound and they don't have mental issues, decides they don't want their spouse or their daughter to take care of them anymore, and they had a valid power of attorney, but the mom rips it up or says no or calls Adult Protective Services. So there was a case I was listening to in front of me in probate court, and the daughter was getting fired by her mother from being her power of attorney, and the daughter was trying to be guardian, and the woman had dementia, and so the person who you're seeking guardianship of comes to court, and the judge asked her, "Why don't you want your daughter?" And the woman said, "Because she's mean to me." And he said, "Okay, tell me what she does." And she said, "Well, she was diabetic. She won't let me eat all the candy I want, and she won't let me drive, and she was in a wheelchair, she was handicapped." And he said, that must be so hard. Okay, what else? Does she visit you? That kind of thing. And so basically that can happen sometimes with dementia. It's very painful. Any other questions? Okay, well, that's a great question. That happens. I mean, through our life, we have changed people to be guardian of our children based on if they're still able or whatever, or somebody dies and we have to change. So you can update that, and there's not an age limit. I've driven clients who can't drive anymore to court to get sworn in as an executor. But you want to try to have maybe 3 or 4 alternates, and then the person can decline and say, "I'm unable or unwilling to sign," or they could pass away or have their own problems. So try to think of 3 or 4 people so you have a line of succession. If you run out of people, then your beneficiaries can ask the court to appoint one of them, okay? So that's why I say look at your documents. Once you have them in place, you need to pull them out every 3 or 4 years and just see, if you can find them, especially if you moved. And also that if the people you named are still the people you want. And then you can have co-guardians. So the situation with husband and wife, he wants his brother, you want your brother. They can be co-guardians. It's a lot harder to work with 2 people on that, so it's good if you could agree. And then for guardians of children, I didn't mention this very much, but you must, if you don't, the court decides. So if you have a wish of who you would trust to raise your children as you would raise them, select somebody to be guardian of your children, and you can select somebody to be trustee of their funds past 18 if you want, within your will, without paying a lot of extra for a fancy trust. But also, the guardian, you may change that person over time, so look at those sections of your will. Diane? Okay, you can appoint a friend, okay? You can appoint somebody you trust. A trustee or power of attorney is somebody you select, okay? And if you don't have any children, that's no problem. You likely have other acquaintances. It is rare for somebody to ask me to help, like in that situation as a client, so I try to get them to dig in their brain, who would you call if you had a medical emergency? Who would you want to know? And it could be that it's, somebody out of state. That's okay, because, we have cell phones, and also that person can be your executor. They are supposed to fly into court and take an oath to follow your will. It used to be by Zoom, but they also can appoint your attorney to be your agent for notices. So you don't have to have a friend in Austin. You can have a friend in California if you want to. And then if you don't have a friend, you can ask an accountant. You can ask an attorney, but if you're asking an attorney, make it clear that you have thought through your friends and family and this is the person that you want, because you don't have any close, family or friends.
Now, a friend is usually more your same age, so don't they need to pick someone older?
Well, that's what he was saying. Get some people in line if that friend is not able. If they're unable or willing, have some people in line. Okay? All right. Is that okay? Any others? Okay. If you have more questions, here's one. You can also, before I answer, you can give me, if you want more information, and I was going to show you real quick what's on the table, you can email me or give me your email if you want information on a particular thing, or call me. Okay, what were you going to say? Right. So did you write on your original will? I'm not trying to embarrass you. Okay, so the old wills used to have Social Security numbers, which is not good. We don't put that in the public record anymore. And then you don't have to have an address for your children, but you could put that in your folder, your planning folder. And what I was going to show you is on the table. This is, you can pass this around. This is what happens if you don't have a will, if you want to look at this chart. And then if you need, if you just want to look at what these other things are that I was talking about, this is a sample medical power of attorney. This is a sample of a financial power. When you look at your documents, make sure you have all this. It's called a statutory durable power of attorney in Texas, and they keep changing the form. And then the directive is how you feel about artificial life support, and it has choices. I want to be kept artificially alive or not. If I have a terminal condition, and then those should be with your will. If you just have a will and not the POAs, you may want the POAs. And like I said, the directive is optional. Okay? Thank you. Thank you. Thank you.
Thank you.
How sweet. Get it close.
Patti, we thank you very much. You did a great job of demonstrating your knowledge of wills and trusts and all the different components that go along with that. So we certainly appreciate that, and thank you for volunteering your time. The G2G committee The G2G committee, on behalf of everyone attending today, thanks you for sharing your expertise and insights. And we all want to say thank you very much, Patti. And we also gave Patti the plant and a card in thanks for what you've done today. Before we start out on our separate paths this afternoon, I would like to recognize the rest of the G2G committee who have worked to put this educational series together for our congregation. Terry King and John Siemens are both out of town, so they're not here today. But I would like to thank Sarah Hamsa, Emily Hobby, Barbara Johnson, Neil Kelly, and Andy McFarland. I also would like to thank Jamie Walker and the Hopes Memorial Garden Committee, and Nancy Patchen and the Hopes hospitality team for desserts and their support. Thank you to Pastor Josh, and thank you to our even ever so helpful coordinator, Nancy Bruno, and to Clark Pingra and Hope's facility staff. Our series, Creating Your Legacy, continues next Sunday at 11:30 during the Christian Ed Hour. Our topic is Creating Lasting Footprints, the financial tools for creating your legacy now and later. Andy McFarland, G2G's financial secretary, will facilitate this session along with Stephanie Marsden from the Texas Presbyterian Foundation. The class will meet in the A&E building, room 104, and will also be available by Zoom. The series will conclude on Sunday, November 19th, with a session led by Pastor Josh on how to create a message for your legacy. He will address memorial service planning and writing a faith statement. G2G invites you all to join us for these classes to continue your plan for your legacy. Thank you all for being a part of this journey. May the peace of our Lord Jesus Christ be with you all. Amen.